Hey, Ryan Witt here, defense attorney in Western Washington. We have noticed over the years that people get very anxious when they hear their case is set for a pre-trial hearing. They think since it's got the word trial in it that they must be going down the road towards trial. So people can be very sophisticated but have very little sophistication about all the different hearings in the criminal process. So if that is the situation you are in and you're a little anxious about the word pretrial hearing, stick around and I'll explain to you everything that can happen at a pretrial hearing, and it's not nearly as terrifying as it sounds. So stick around. Okay, let's start this off by talking about what a pretrial hearing is not. There will not be a spontaneous resolution forced upon you. There will not be a jury sitting there in judgment over you. There will not be a law enforcement officer there, and there will not be an alleged victim there to testify against you. What these are really is it's a court-imposed kind of status hearing where they want to make sure things are moving forward, where the parties are brought together. Defense, prosecution are kind of forced together to get the case moving in a forward fashion. Now, they are very busy hearings. It's the most, common type of hearing, and the courtrooms can be absolutely packed, and everybody there is in the same situation that you are in. And there is really just four things that can happen at a pretrial hearing. Number one, there can be an agreed resolution. Now, that could be entry of a plea, entry of a plea to an amended charge, could be entry of a Pre-Trial Diversion Agreement or PDA, entry of an SOC or Stipulated Order of Continuance, or entry of a Compromise of Misdemeanor. Those are agreed resolutions that are handled on this calendar, and they're usually handled at the end because they're a little bit more time consuming. Then, if a matter can't be resolved, like in the section we just talked about, there could be a continuance. Now, there's all kinds of reasons for continuances. It could be you're seeking more evidence, you want to do interviews of the state's witnesses. It could be to have ongoing negotiations. It could be to work out a compromise of misdemeanor. And you can also sometimes have the court entertain changing conditions of release. So it's a very important hearing, even if you're just continuing it, because some very strategic things can happen. If you are doing a continuance, you need to talk to your attorney beforehand. Well, and they should be reaching out to you beforehand because you need to go through some forms. There typically is going to be the requirement of a speedy trial waiver where the court wants you to reset a new commencement date or basically reset a new 90-day speedy trial clock. And once that's done, the court can grant you a continuance, and they're usually in Washington 30 to 45 days out. So you're at a pretrial hearing, and then you just get set over to another pretrial hearing. It doesn't mean that your case is on track to go to trial. The third thing can be motions, okay? If you're not being a resolution or a continuance, your defense attorney may say you need to do motions to dismiss or motions to suppress. And it's just as it seems. You're not doing those motions on that date, but you are scheduling something in the future, what they would call a 3-5 or 3-6 hearing, where your defense attorney strategically wants to argue to the court that the state shouldn't be allowed to introduce certain types of evidence or maybe your statements before trial. And those types of hearings can be dispositive, meaning they can resolve the case, or they can just surgically take out little bits of evidence, but they aren't necessarily dispositive. So again, that's setting for motions. And finally, if the other avenues have not worked out and people are at an absolute impasse, there's no budging between defense and the state or defense and whatever governmental entity, it could be a city, that's when, usually the last case scenario is you're setting for trial. And when you set for trial, you determine, future dates. Will there need to be a readiness date? Will there need to be a trial status date? Will there need to be a 3-5 date where you talk about statements coming in? But that is setting for trial. Now, I kind of make all those sound evenly distributed, and they are not. Number two, the continuance is common, but number one, these cases almost always, and I should say 98, 99% are resolved through some type of resolution, like some agreed resolution, a reduction in charges. If we're talking about a DUI, maybe it's a a reduction down to a negligent driving first degree or an amendment to a reckless, where there's usually always some type of agreed resolution that both you and the state attorney put forth to the judge. And then, when you're both putting that forth and it's agreed and argued to the judges will almost always resolve the case in the matter that's been put forth to the court. If they don't, the argument is it causes a chilling effect on negotiations and things get set for trial. So, 99 point whatever percent of agreed resolutions that are put forth to the judge will follow those recommendations. So if you have a pretrial hearing coming up, all is not lost. Just because the word trial is in there does not mean you're going to trial. I would say of our cases, it's probably in that 98, 99% where there may be the requirement for a continuance. Yes, there may have to be more negotiation or more investigation, but they do almost always resolve with some type of agreed resolution. So if you've got a pretrial hearing coming up, get in touch with your attorney, even if it's not us, because forms are required. If there's an agreement, there's obviously paperwork you're going to need to go through. And if it's just going to be a continuance, well, same thing, because there's a speedy trial waiver. Hopefully this has answered your questions and settled whatever jitters you had about a pretrial conference. And if this raises more questions, go ahead and drop them in the comments. We'll do our best to answer them there. Or maybe we'll just drop a new video answering your questions. So hopefully this content was helpful to you, and it would be helpful to us if you would like and subscribe. And thank you for watching.